And there are some materials on that back table. You can just take one of each. I'm papering you in the tradition of lawyers. So we can just have a conversation or listen. I've been doing seclusion and restraints for the last hour in this room, and I was on a submarine for 3.5 years, and this has about the same aesthetic quality and light. So bear with me. The Greenling 614, it was a sister to the Thresher. It's a fast attack out of the East Coast. It's a radio man in crypto and.
Well, my submersible ship I was on, but she was ST.
Okay. Okay. Well, that's not a bad lead into this idea of adulthood, because when I was younger, I don't know, I ended up a lawyer. I teach at the University of Iowa Clinical Law Program, and I represent individuals and organizations, mostly consultant work now, a lot of policy and estate planning as well. And but when I was growing up, JD stood for something different. So at the age of majority, there was an even bet that I was either going to be a rabbi, a physicist, or a lifer in prison. So I took a long way about becoming. So today, it's supposed to be a conversation. And I've got a PowerPoint, but I'd really like to know in a couple of minutes what you came to learn today and what you need to know. Excuse me? How to get rid of the kid? I just have grandchildren, so I keep getting more. Okay. Yeah.
I work at ASK, by the way. My name is Jessica Gutimo, but I also have a child who's over 18.
Okay.
I've transitioned to adulthood during pandemic, so.
Okay.
Yeah, so that's kind of my filter here. Is I feel blessed to be here to hear your conversation and to contribute as much as I can.
Okay.
I'm just very much interested in knowing the adulthood piece and.
Okay, because I'm just a lawyer. I guide people and I help them make decisions. But you have more experience than I ever will. I have a daughter and she has disabilities as well, and one granddaughter as well. Twins don't yet. They consider me their burden on this. But they're all special in their own way, and so that's parents talking to parents, and people coming and transitioning into adulthood are the best people to go through this. So I'd like you to share and exchange ideas as well. Anything in particular?
I am not a parent, but.
Okay. Okay. What kind of provider?
I am working living.
Okay. Okay.
We have 2 children with special needs.
Okay.
They're younger still, but I don't know what they would do.
Okay. So the idea is it's all.
I don't even know.
Okay.
We have 2 children, one of which has disabilities and the other.
Okay.
My sister's 25 and still trying to get to that full autonomy, so she's got her own struggles on top of it.
Yeah. So how to become independent and how to help people come independent without being an anchor, which I'm all accused of as well. So no matter what our good intentions are, there's a way we can hold people back.
I'm a 17-year-old that's going to turn 18 in August, and I don't know where to start.
Okay, that's
So I'll just help you.
And I'm right after her. Mine just turned 18.
okay.
Okay. Tessie and I came for kind of the same reason, like, do I need guardianship? She lives at home right now, and we're doing okay, but she would like to be independent. So when I support her with that independence and get a job, it's not really, what do we do then? Because right now I feel like she's
Okay, and a lot of these are personal dimensions and personal dynamics. I can tell you the tools that the law can provide, and it's a matter of how you make the best use of them, because there is no one size fits all. And so Tessa, what is it that you would like to know today? Or what you'd like your mom to know? Okay. And we do a lot of estate planning for adults. And I have law students who are in their 20s and they're married. And the first question I usually ask when we're going through a lot of these tools is, how many of you have a power of attorney, medical power of attorney? Whoa! How many of you have a financial power of attorney? How many of you have a living...
That's one of our questions. Because what I understood is we cannot leave our child anything, an inheritance, because she's special needs on waivers.
Okay, so that's one of the issues is what kind of financial tools can you create, or a lot of times we call them wrappers. You know, whether they're a trust or they're a special account that is limited by age. And those are really good questions, because when we're talking about money, and that's usually, the personal dynamics are the hardest for me. You know, the idea is I have a child, and they're 18, and the idea is I'm worried about their safety, their security, sex, procreation, kids, you know, injury. And no matter what you are, whether you're a guardian or an agent, I think the first realization is you don't have any control to the degree you think you have it. And the law doesn't provide many options for you, but I will tell you what tools you can use and what their strengths and limitations are. I don't know why this thing keeps popping up and out. So what happens, and it's all in personal autonomy. And the way you're treated and the law treats you when you reach age 18, I've given you this great booklet on your own. And Tessa, you should read it, and moms, you should read it, because it says what happens when the clock strikes and it turns 18. And then the different ways that you can manage a relationship, or that you can assume control of decision making of someone else, or that they can allow you, formally or informally, to share decision making, or to appoint you or designate you to make decisions. And part of it has to do with the ability of and I'll say child, even though they're an adult. I will just call it the adult. 18-year-old is the easier way. Then what are the ways they can do it, and what are the different models that are used? And I can talk about the tools. Anything specific, just ask a question. I'll talk about the pros and cons, and I have no idea why that keeps going on, but it likes it. I have no idea. Let me minimize it. Maybe that will get it out of our way. Good. Okay, and if you have any questions as we go, please ask them. And okay, so what happens when you reach the age of 18? You have the right to marry. You can vote. Jury duty, which means they can round you up and you can sit for a jury whether you like it or not. You can enlist in the military. You have the right then to look for jobs, and they will hire you, even though you can be hired at a younger age under Iowa law. But usually you're eligible for full-time employment with benefits and others. You also have the right to do consumer transactions, contracts. When you're under 18, any contract that you have is essentially voidable, unless it's for necessaries. Rent, right? Food. If someone under 18 goes out and rents a house, even though they're under 18, they're still going to be responsible for that. They may try to get you to be responsible for it as well. But also, you can make a will. You can make a power of attorney. And powers of attorney are just a way, and I'm going to send you the slides as well, so you'll have them. And I'm going to also send you a resource guide which has forms for all of these from an older workshop. So if you can just write down the email, because I'm not sure you don't pre-register here. I will send you all of those So you'll have them for yourself and also for anyone else in your life, because you don't have to be a parent. So a power of attorney is a way that a person can voluntarily say for health care, then if I'm unable to make health care decisions, then I'm going to designate you to do so. And it's only when a doctor says that I can't make those decisions. And there's another one for finances, but it's a little different for money than it is for health care. And I'll talk about that. Because with health care, you're talking face-to-face with the doctor. The doctor looks at me and said, I'm under anesthesia, or the roof caved in on me. I can't communicate. The doctor's the one that makes the decision. And she charts it and says, okay, who's up first on that document? With a bank, they have no idea that I may be able to make decisions or not. And so my agent, maybe my wife, comes and says, I want to take all the money out of Len's account, because we may have more than one joint account. And without the power of attorney, they'll say, I don't care if you're married. And we'll talk about what you need to know, what happens if you do nothing. If you continue not to have powers of attorney or allow your children, children with the ability to give informed consent and understand. That's the difficult part of this when you have children with disabilities. Is it an intellectual impairment? Is it a developmental disability? To what degree does it impair their ability to understand information and give their consent? And there are clients I've had, and we've represented parents who wanted to be guardian, and also people under guardianship who did not have that ability to make decisions. But merely because you have a disability does not mean you are incompetent to make decisions or considered incapacitated or lack the ability to do so. Just when you go to people and you want to fill out some of these forms, they're going to say, well, Len, your granddaughter has, she has an intellectual disability, or your dad has dementia. We can never do someone who is diagnosed with dementia, because they can never, and we've done ceremonies and had them sign it so long as we were assured that the person face to face could repeat back to us what they were signing and why and what options they have. So merely because someone has a diagnosis of dementia, even in a facility, does not eliminate that need. And we've done things as well. We have executed documents with the nursing staff being present with a woman who was in her 80s, and they thought she would never be able to understand a thing. And when we did her signing, she understood everything from 1923 to present, everybody involved in her life. And they witnessed her will. And they said, you're the only people, and that means a law student and I, who actually got her to say things that were intelligible, accurate, and prove she could understand and give her consent. Okay. Okay. So there are a lot of decisional models. This is what I was looking for. Who's heard of supported decision making? Okay, well, it's a model now where, and it's the law in certain states, where instead of guardianships, instead of powers of attorney, instead of different authorizations, the law allows for contracts between an individual so they can craft who they want involved in their life to help them to make decisions. Okay, and Iowa does not have a law for it, and there is no universal law, but this was one of the first models, and I said, oh gosh, I don't understand a thing. This is the way we do about estate planning for adults, and it's how we would introduce you to this whole issue. The first thing is we would take you on as a client. It's always client-centered, and you can put your adult in the center of this as well. And who's made an important decision recently? Okay, what was your decision?
Buying a house.
Whoa, okay. Now, what kind of work backdrop did you do or homework did you do to find out about things?
Not nearly as much as I should have.
Okay. Okay, that's the first comment, is when you're an adult, you're free to make decisions that other people consider beneficial, harmful, foolish, and stupid. And our children who are turning 18 deserve the same rights. The question is, some may not be able to negotiate the world safely without someone else assisting them or actually making decisions for them. So you didn't do enough homework. What did you do?
I had spoken to a realtor. I had asked questions about my eligibility for a mortgage. I had researched homes that were within the budget that I was pre-qualified for. I read all the contracts and the paperwork that was provided to me as I went through the process. And I listened to the advice of friends and relatives who had done it before.
Okay, so think about all the people that we enlist to help us. Who made the final decision about the purchase?
Me.
Okay. Is there a significant other in your life that?
Outside from the kid, no.
Okay, well, the kid. Okay, so here's what we think about it. And here's the reason why some people need assistance at some time in their life. And this is what the students call the wheel of life or the wheel of death. They helped create it. And it reminds us that every time we are going to take an action or make a decision, we have to look and see what other parts might be affected. So you were talking about money for your child, right? So if you wanted to, let's say your child wanted to go to work, the adult wanted to go to work, and they're on SSI, then you have to think about, how is that going to affect their means-tested benefits? Because their income and resource rules. What's going to happen? What taxes might be owed as well? What insurance they might need? And are they going to talk with their parents? How is it going to affect their health? And every time, what we do is every time someone's going to say, I want to leave money, Tessa, you're going to inherit a fortune. And the question is, if someone writes a will, for example, and they say, you get this money, moms and dads are always well-intentioned. We're really good. But that could disqualify Tessa from many things. So you have to think about how you would make that transfer of money now or in the future so it would not disqualify. And that's the idea of the person. We individually have to think about these issues before you bought a house, right? Who's going to finance it? What kind of insurance you might need once you get it? What the interest rates might be? Is it going to count as a home if you're on Medicaid or SSI? Is it exempt when you're counting? Because through the spectrum of disability, many of us are on SSI, Medicaid, or other benefits. And the other thing is, what happens when someone else is in the picture? And this is how I look at decision making. And it's a spectrum. And the first one is the most restricted. That means the individual has little or no say whatsoever. And in this world, it would be a guardianship. It means that a person's civil rights are stripped to the degree a court says you can or cannot do something without the consent of the guardian or the court. The next one, it's limited, and that can be in a guardianship of the person or the money as well. For a guardian is responsible for the person, a conservator is responsible for the money of that person. But that necessarily doesn't include a trust or special other accounts. It's only property owned by the child, which will now be part of the conservators. Shared is to what degree a guardian or an agent that the child or adult allows to be in their life, to what degree a guardian would allow their protected person, that's what it's called now. It used to be called the ward. To what degree I'm going to allow the protected person to do things on their own with my supervising in some different way. And the other is supporting. Yes, without the need for a contract, a guardianship, an agent. Yeah, but in certain states, it's a supported decision-making agreement, and I've given you materials on that from Wisconsin, which I think are excellent. Yes, sir.
So, like my child turned 18, we put her under a guardianship, I think?
That's the reflex. Okay, did you apply for guardianship?
Yes.
Okay, are you a conservator as well?
I don't know the term.
Okay, well, the conservator, when you apply, the guardian is responsible for living arrangements, it's responsible for medical and health care, and you can apply to be both a conservator, which takes care of the money. Now, oftentimes, yeah,
As far as I understand, we take care of the money too.
that's a good, and we'll talk about, great, you can teach the class too, this is great. There are different ways to manage money, and we'll go through those. One is a conservator. And that means the conservator really has to go to court every time they want to make a transaction and do money. The adult who's the protected person has no rights whatsoever over that money. They cannot enter into a contract, except maybe marriage. Anything that they do while under a conservatorship is voidable. So if they go on the internet and order $35,000 worth of candy canes or whatever books, the conservator can just say, we're not paying. And that's the protection. That's why people might want a conservatorship. It's because if someone is extremely vulnerable to exploitation, that's probably the only guarantee you're going to have that you can protect that adult. If you're an agent under a power of attorney, it's completely different, and I'll explain those rules as well. So whether you're the guardian or the agent, and we'll talk about it, with the idea is you want the individual sooner or later, if at all possible, and a lot of times with intellectual disabilities, barring some kind of breakthrough medically or neurologically, the person may not be capable of regaining their decision-making ability. Because if they do, then they can limit the guardianship. Meaning they can say, my guardian can make decisions about where I live, but not about the health care. Because I now have ability to do that. And that's what guardians are supposed to do as well. Okay. Okay. And, well, here we go. Okay, so the default is usually the guardianship. It's usually the first thing teachers tell you or doctors. Get a guardianship, Len, because at age 18, you're out of the picture. You have as long as your person is an adult, you cannot be involved in their life unless the law allows it. You can't tell them where to live. You don't have to sign their contracts. They can make powers of attorney and living wills, and they can do what they want. They can marry without your permission. And you're actually closed off as a parent. So the world opens up for your child or whatever relationship it is, and it can be friends, because this is the same thing for older people. We're doing the same planning for people who are in their 60s, 70s, 40s as well. The default is guardianship, and it's the most restrictive. And here is the legal test. And it's really about the decision-making so impaired that the person is unable to attend to certain life decisions without physical injury or illness. And a lot of times that's mental health or intellectual disabilities as well. And the conservatorship has a similar thing. That means if you file for a guardianship, you have to file information, and we do it from special education teachers and doctors, that show the person does not have the ability to do these as well. And it's a formal court process. The guardian has to file reports. And I've given you a copy of what's called the initial care plan for a guardian. So this is what you have to fill out once, and then every year, the kind of information that you have to tell the court, because even though you're the guardian, and this is what a lot of people don't remember as guardians, it's your obligation to maximize the independent living skills of the protected person. It's to get whatever third-party assistance is needed to remove any barriers or help them make decisions without someone who's supervised by the court. It also has to be in the best interest of the respondent. Most of this is done by paper. There's rarely a hearing. You upload them electronically. You attach the affidavits. And as a parent or a son or a daughter or nephew or partner, you have to understand that you're stripping the person of their civil rights. They still can marry, they still can vote, but the law says judges can take away those rights. And the new law actually says that they can make a determination without anything else but what was filed in the original petition. And the petition says, here's Lynn's abilities, functional abilities, limitations, here's the proof, and because of that, I want to make all guardianship decisions. And that's usually the way it is. It's called plenary, and the person has no rights. The person's entitled to a lawyer. And I represent a lot of people where the individuals have intellectual disabilities that are not going to improve over time, which means the court's more accepting, and there's a reason behind saying that the child needs a guardian full-time and a conservator. When I've represented people who've had strokes and they can still make different decisions, we've asked the court only allow the guardian or conservator to make different decisions and leave the rest to the person. And ideally, when the person from the stroke recovers their decision-making ability, you terminate and the guardianship. It's really hard for parents to do that. We had to go to court, and actually on Christmas Eve, the court stayed open because the parent of a 34-year-old, they didn't want to give up. So our client lived independently. She was going to health care, doing everything, but mom was the guardian, and there's a difference between the role of guardian and mom or dad.
How do you get a lawyer?
How do you get a lawyer?
That is going to represent them. She doesn't have funds.
Okay, that's the hard part right now in the law, because under the new law, in many places in Iowa, if I'm going to file on your behalf, Tessa's entitled to a lawyer. Okay, but now I'm supposed to find a lawyer for Tessa. And I don't mean it's just you, Tessa. It's my granddaughter as well. But the lawyer who represents the respondent, that's what they call the person who's going to be under a guardianship, can't get out of being the lawyer until they find a substitute. So when I used to represent abused and neglected kids, I was their lawyer till age 18. If the court won't let me out unless I find another lawyer, I'm going to be representing my granddaughter until I die. So that's why it's hard to get lawyers now unless you have a lot of money. Otherwise, the person is entitled to, if they don't have money, and it's the person, not the parent, to have a lawyer at county expense. That means the county will pay the lawyer, but they only pay $65 an hour. And for a law firm, it costs them more to process the paperwork. There are lawyers who will do guardianships, though, and if you call me, I've got my information. There's a network, but sometimes it's going to cost $1,500 to $2,500 with just an uncontested guardianship. So that's what makes it problematic right now. We're trying to get the law changed to say once the guardian's appointed, the lawyer can withdraw.
My child had a guardian ad litem that I didn't have to pay for. I think it was court appointed because he was receiving SSI. But I'm not a parent who had to do
Okay, well, sometimes they'll call them guardian ad litem, but Iowa only has it in the juvenile court, and they're called attorney. You're entitled to an attorney. Now, sometimes they'll do dual role, but my duties as a lawyer are completely different from that of a guardian ad litem, and now they call them court visitors. There are people who investigate on behalf of the person, but don't represent them. Yes?
So when we filled out ours, some guy, lawyer came, visit our home, talk to her, to represent her. So I understood the court appointed a lawyer for her.
Well, then they did. And where do you live?
Waterloo.
Great, because they don't do it in Iowa City, and they don't do it in many other counties. She's entitled to a lawyer. And the lawyer, and this is what we do, we go to the home, and depending on the person's ability to comprehend things, we have to tell them what the consequences are of having someone be your guardian or conservator. And a lot of times it has to be very rudimentary. Other times the persons can understand things and you can have more of a conversation. But then you have to report to the court and you have to either decide, am I going to agree or am I going to challenge it? And have a hearing.
Was basically to find out whether she was competent enough to even answer a question,
Okay, well,
besides if she went for a tablet or not.
yep. And that's what and we meet with people, and there's an art form about meeting with people as well, and where to meet with them, and when you can have the parents present and when you can't, and other things. So,
Sorry, but then you pay for a lawyer for yourself to get guardianship?
Yes.
And then you pay for
no, the
lawyer
court can pay if the child's on SSI or doesn't have, it's a certain income amount. And anyone who's on, and children generally don't have any money, then you're entitled to it, and you bill the county. The court has to approve that. And some courts will appoint lawyers who are willing to do it. And the question is, did they release that lawyer after he represented your daughter? And that's it, because he still may be around next year. There's reports every year as well.
And they report this, or we?
Oh,
Guardianship?
if you get guardianship, the guardian fills it out. Now, you can ask a lawyer to, but if you're getting billed out, then that's one of the new reporting requirements, because guardians were paying lip service. Many guardians weren't even visiting or talking with the person they were responsible for. They had no idea what they were doing, so the law changed to make sure that there was some accountability. It went way overboard, in my opinion, and we're trying to change the law now. But this way, if someone were reading the information, they'd get really excellent understanding about what the guardian was doing and what progress the person was making toward independent living. But no one has the time to read these carefully. The judges don't, and there's no one in the court system that has been appointed to do this. Jessica?
I was just going to share, I guess I had an aha moment. So we have guardianship over my son, and I guess I didn't realize this, but when you mentioned about the lawyer kind of being assigned for life or whichever, we went to a lawyer for guardianship, but then when it came to the annual reports, the first year that we had to do that annual report, it went through the lawyer, but then I found it to be redundant, and I was like, how do I remove the third-party situation here? I said, I can just upload this stuff myself.
If you're the guardian, you get your own account number, and you can ditch your lawyer.
And that's what I did, and that's what I wanted to share.
No, that's what you can do. After the lawyer for the guardian can withdraw at any time. And most of the time, the people who are guardians will fill out the forms themselves, okay, or parent groups get together, because we have a lot of people that don't speak English as their first language, and they have difficulty with the forms, because I do as well. So we have parent groups assist, because that's the only way. And even though I'm not representing people, we get calls an awful lot. Okay, so that's the,
It's debilitating though, every year what it's due, it's like, they don't send it.
Yeah, my lawyer, after the judge granted the guardianship, was like, okay, that's it, I'm done. And I called him when the papers were
Okay. It is. Okay. There's a great guardianship manual online as well. There are two of them, one from the Department of Human Services, your role as a guardian, and the other is through Iowa Legal Aid and the DD Council, Developmental Disabilities. I will give it to you. Yeah.
They will send you a letter that says you're in contempt. So you will get a
Yes.
notification.
But they give you time now. Usually they'll say 30 days. You just call the court clerk and say, I need help. A lot of times the court clerks won't fill out forms for you, but they'll help you. They're usually the best people. Okay, so what are the alternatives? Because that's really what we're talking about. For there's two worlds, right? And they don't usually join except when you have to pay for health care. Then you need the finances. The first one is the medical power of attorney. And I can show you the forms, but basically it's someone who's 18 years or older, right, that empowers someone or someone in succession, they can be one or two or three, to make medical decisions, including simple, complex, and end-of-life decisions. And they can always change their mind. Problem with the agent is they don't have to serve. Bless you, there's no compulsion. They can withdraw or say, no way. So you have to make sure that the people are willing and able to do it and maybe close by, although not necessarily, because with Zoom and other things, doctors can talk with you. And all the person has to do is say, I revoke it, but it's best in writing. You can revoke it by doing a new one as well. And I've got a packet that I'll provide to you that has the forms, other things. Medical power of attorney governs all decision-making, but it's appointing someone. There are no instructions. The living will is a document by which you instruct your doctors about which end-of-life treatments and procedures you want withheld or withdrawn or administered. And we've got many of them, many forms. We do our own as well. These are all prescribed by law. They're in the Iowa Code and the Iowa statute. So they want you to follow a form, but it doesn't have to be completely restricted. The standby guardianship is you can do this for your children until they're 18. But let's say I'm worried that my power of attorney won't work, and they won't accept, or you just decide you're not going to be my health care agent. And I want to have a backup and they're not ready. I put a standby guardianship, which is a piece of paper saying, oh, in the event that I can't make health care decisions and there needs to be a guardian, you can do it for a conservator, I hereby nominate Layla. And you either give that to Layla or you file it with the court. And when something happens, she's first in for the guardianship. So if my parents are trying to be the guardians at the same time, that's a nomination and the court will give her priority. And the other ones are, gosh, here we go again.
Young man, do you know how to fix that?
Yeah, you're bumping the flash drive with your hand.
Oh, is that it?
Yep. And every time you do it,
Okay.
it reconnects it. Sorry.
No, come on up here. You can run this too.
Have a nice day, guys, though.
And that's the one, so much for independent living at my age. And then people are already, my granddaughters are saying, Pa, and that's my name tag, Len and Pa, who's going to make decisions for you? And we have powers of attorney and living wills as well. Now we switch to the medical side, to the money side, and you have the financial power of attorney, which is called statutory. And an adult can give authority for someone to make as many or as few non-medical decisions. But here's a little different. They can give authority, and what's your name? Shelley, right away. The minute she gets this document, she can use it. Take all my money and run to Rio or wherever she wants to. And then she can say, well, what's your name? Curran? Okay, well, I can say, well, Curran can't use it unless and until a doctor certifies in writing that I can't make decisions. So that way, even though I give you the power, you can't use it until a doctor says in writing. Because you go to the bank, right? Got that power of attorney. Shelley shows up and she can use it right away. Right? Curran shows up and they say, is Len, where's your certification in writing from a doctor? Either certification or that I'm in prison or in custody or that I'm out of the US and can't return. And I don't know why they did that, but after COVID, I now understand. And also because I have clients that travel to Iran.
Well, you're in the service, you ought to know that one anyway.
Yep, exactly. That was a long time ago. Okay, so what do most of us do? And you've all done nothing except for guardianship. You have a question?
I'm trying to grasp what needs to happen, because it sounds like I need to do something to get financial power of attorney.
Yes, you do.
I need to get a living will, I need to get medical power of attorney, I need to do representative payee, I mean, do I have to?
You don't have to do all of them. And that, let me go back to those. Okay, so let's just talk money. And if your child is going to be on SSI and Medicaid, and there is no other source of income, then there is no reason to become a conservator. Because the only money that person, if they receive it, is Social Security or sometimes VA, then you can go to the Social Security Administration and be appointed the representative payee. But that payee is only responsible for that SSI money, no more, no less. So, but if that's the only money the adult is going to have, then you don't need a conservator because you already have somebody you're accounting to Social Security for the money. And you have to account. It's not as onerous as a conservatorship. So these documents are pretty straightforward, and you don't need a lawyer for them. And they're called advanced directives. The time when you would need a conservatorship, in my opinion, even though it's only SSI, is if the person can be vulnerable to exploitation. Door-to-door salespeople, internet salespeople, subscription, they go to a store, they get a hold of your credit card. Now, and there are different arrangements you can make, but the other thing is you can put their name on accounts to teach them and also to have them withdraw money with your supervision or independently. You got to be careful if you put their name on accounts, though, because it may be a resource that Social Security does. Considers for SSI. But other times you can just open an ATM account and just have very limited money and make sure it's under the resource amount. So there are different ways you can teach money management. Another way to have money for someone under 21 is a Uniform Transfers to Minors Act account, or UGMA, UTMA. And that grandparents use all the time. It's no, you just say, I hereby give the money, whether it's in a will or whether it's a piece of paper or a bank account or insurance beneficiary designation forms. Uniform Transfers to Minors Act account, UTMA, and I'll send these slides to you as well. And that UTMA is the property of the custodian. So SSI won't count it. But at age 21, you have to turn it over. Even if the person is a spendthrift or would be disqualified, you don't have a choice. At age 21, it becomes theirs. Iowa's, the majority is age 18, but the account stays until they're 21. So that means I have to turn it over if there's anything left. But that means the person can come to you and ask you for the money. And you manage it. There's no court supervision. There's no power of attorney. It's just an account. And a lot of people do that for gifts, grandparent gifts account, as I've said before. There is another trust, and I don't want to go into special needs or supplemental, because those you need lawyers for, And the idea is, can you have a legal wrapper? It's called a trust because it holds money and someone administers it. And the idea is, while, I didn't even touch that one, that you can decide who's going to manage it if something happens to you and who's the beneficiary. If it's the adult and the person's on means-tested benefits, then you have to make sure either that the trust will not be considered a resource. And those are supplemental needs trust or special needs trusts. But there are two kinds. One is a payback trust. And that means whatever's left of money after the child dies gets paid to the Department of Human Services to reimburse for Medicaid. Nope, that's another one. This is a trust. This is one wrapper, and I can do these things for 5 hours. That's why. Okay, I know. But the idea, each one of these has different rules. And the ABLE account is a separate wrapper. You got a trust. There's a UTMA account. That's one wrapper. It's just think of it as an envelope. Okay, and you got to think who's going to manage the money and what is Social Security or Medicaid going to count it, and then what happens to the money after death. Okay, that's sort of and the other one is the ABLE account, and that can be started by a parent or anyone else or the individual. And there's a force field around that from Social Security and from Medicaid, because you're allowed to continue to accrue money up to $16,000 a year, and just think nobody can get through it. You can get through to the Dark Star, but you can't get through to that ABLE account.
I did have a question. So my son does not have any intellectual disabilities. He has all physical disabilities.
Yep.
So it would be an ABLE account, is my understanding, that we would need to set up for him.
Well, you can use an ABLE account. You can have sign a statutory power of attorney, financial power, allowing you to make decisions for him when he really can't make decisions. So these are a lot of tools, and I know it's difficult in 50 minutes to go through. The reason is, what happens if you don't have this? And if you don't have a financial power of attorney, if Tessa does not give you that, and she has an account, and you need to get that money, and you go to the bank, and I'm Tessa's mom, and they go, that's nice. Come back when you have some kind of authority from Tessa. And if your name was on the account, there would be no problem, right? And there are different ways you can put your name on the account. But if you really need to get to that money for Tessa, and the only other option would be to become a conservator and get a court order. So the idea of these powers of attorney is it avoids going to court. The idea, so you don't have to establish a guardianship if you don't need to or want to, and you don't have to get a conservatorship. The spectrum is independence, right? Sharing, powers of attorney, right? Limited guardianship and guardianship. If you don't have a medical power of attorney, there's no default in the law. Under Iowa law, spouses are responsible for each other. So they can make decisions. The hospital will say, okay, Len, you didn't have a power of attorney, your wife has made decisions for you. And a lot of times the doctor's lawyer will say, okay, who's going to inherit? And they'll say, okay, spouse, well, you're not married. Adult children are the majority of them. And they'll allow sometimes. If they don't accept the default, you have to go and become the guardian. The thing about a guardian is the guardian needs the court's permission for non-emergency medical decisions and for end-of-life decisions. So if you were the guardian of Tessa, you'd have to go to the court for permission. And you'd also have to go to the court if you wanted to move Tessa to a more restrictive setting, a congregate apartment building. But if she gave you a power of attorney for health care, you don't have to go to a court to get permission. This 50-cent form gives you that entree, and the doctors will listen to it, but only when she's unable to make decisions, wherein a guardian gets to make them all the time. If you don't have a living will, there's actually, for some reason, they tell you what happens if you're on your deathbed. Then your agent is the first one to make decisions. Then the legal guardian, then your spouse.
Healthcare agent, a doctor?
No, the healthcare agent is actually under the power of attorney. So here, healthcare agent is power of attorney. Guardian, right, is the legal guardian, conservator. And under these others, they're trustees or custodians. Whew. Okay.
What if the child has filled out a form that says that you can have all of the information? Like they asked us when she was 18, oh, well, if you're the one who's gonna go pick up her meds, do you need to fill out, would you like to
No.
fill out this form so she'll share all the information?
The easiest thing, if they'll accept it, is a written authorization saying, here, mom can be with me at special ed, you can do that, the school. In fact, you can show up with them and they'll take verbal most of the time, although they may want Tessa to do something in writing. The next one is emergency and next of kin, because they're the ones who are going to be contacted. And they always ask you, so that's what Tessa would do. And you might do that and have Tessa or someone else be contacted. Whatever you're doing for an adult child with decision-making ability, you can do for yourself. So what you have to do is put yourself in their shoes and just say, okay, what would I do for myself? Can I fill out a medical power? And who would I want as an agent? And who would I want as a backup agent? And then Tessa should do the same thing. Okay, who do I trust? And it may not be you, Mom. And those are some of the conversations you have. It's the same thing with the will. Because one, you've got to trust the agent, right? And they have to agree to do it. Now we have one student, and she wanted living wills and healthcare power, but her husband faints at the sight of blood. So we said, well, maybe he is not the person, because a lot of times these healthcare powers are when the roof caves in and you're knocked out cold, right? I'm knocked out and I'm on my deathbed. None of us can communicate, and the doctors want a decision maker. So they're going to look for a power of attorney, health care, and see who your agent is. They're going to look for a health care agent for me too, but they'll also look for a living will, which are my instructions about end of life. So I'm saying, Sheila, I'm appointing you as agent. But I'm telling you, doctor, that I don't care what she says. You give me everything. You give me intubation. You feed me. You restart my heart. Or you say, I don't want any of this. If I should be, in circumstances where you're terminal, it means you have a progressive, they can't stop it and you're going to die relatively soon. Or you're in a permanent state of unconsciousness, which to a reasonable degree of medical certainty, there can be no recovery. I've been using these forms for quite a while. So that means there's no hope as well. I know there was a lot here. This is sort of a half-day workshop. And I can sort of straighten it out for you, but the idea is, think about driving a car and having your Tessa or someone teaching, she's on the wheel. And there are different ways you can do it, or a boat, right? First you put it on autopilot and do nothing. And that's when we don't seek a guardianship for people, because we've had prospective guardians who said, I just let the kids watch TV and eat bonbons all day. And I said, we cannot, we're not going to represent you because you're not taking any actions. And that's one thing you're swearing to the court you're going to do. So that's autopilot. The second one is the guardian. I'm at the wheel, butt out, right? I'm the one in charge and you can't say no. Or as a guardian, you could say, come on up. Let me help you, because you can allow Tessa to be at the wheel with you. And then the idea of how much independence and control you want to have. Some people, when you're on a wheel, and I was in the Navy and I was a battle helmsman, so I used to do this, is can you allow her to have the big wheel, but you sort of help guide it. And some of those, you appoint her an agent, right? She's your guardian, you take control. Then it's an agent, Mom, you can do it, but only when I'm not able to do it myself. Then it's shared, and then it's supportive. You hire someone to teach her how to steer and do it. And then the final thing is you get rid of all of this because you've assisted her in understanding and you let her take the wheel. I'm not sure parents are the best thing to do. I've tried to teach my daughter how to drive. And I learned it's always good to get other people. And just lastly, it's supported decision-making focuses on what the person wants, what their needs are, who they might want involved. And a lot of times it's where they should live. Can they make decisions? How do they stop bullies? Can I have sex? That's the most difficult question we get from guardians. How do I stop my child with an intellectual disability who does not understand procreation? And that's parenting. Forget guardianship. So, thank you. I'm just completely lawed out right now, and I know you are. I'm sorry for flooding you with a lot. What I'm going to give you is a guide that explains all of these documents and gives you copies of them. Okay, the other thing is the handouts. The handouts explain everything about guardianships, payees, able accounts. So the idea was great. I will mail all of those to you. Thank you for your patience.
I'll collect all the surveys of those of you that have them filled out.
Intellectually, I will not have to make any decisions for him. It's just protecting his Medicare and Social Security.
Yep.
So that's what I'm struggling with as far as like, I can't leave everything to him, right?
Well, okay, so here's the way you can do it.
Okay,
You can set up a trust during your lifetime,
okay,
but you have to go to an attorney who knows about trusts that the money in the trust will not be considered by SSI or Medicaid to be a countable resource toward the $2,000 limit.
right.
But to understand that whenever they make a payment from the trust, that's going to be considered income. So when you're doing is you have to appoint a trustee, a person who knows what those rules are, because they have to know.
Yeah, trying to figure out the rules is impossible myself.
Well, it is, and that's why trustees earn a percentage of the money. But they'll say, well, I can buy an apartment for your child, put it in the trust's name, and then if something happens to your child, you can decide who you want that house to go to. But during the child's lifetime, that's an exempt resource. Social Security doesn't count one house of any value, right? And there are other things that Social Security doesn't count. And that's why you go to, it is yourself, and that's why trust departments do this. Not, well, we used to,
Okay,
but where do you live?
Western Wayne.
Okay,